Welcome. My name is Sierra Sanderson, and I'm an attorney with MNK Law. At MNK Law, we are more than just your attorney. Our mission is to listen, understand, solve, and execute challenges you face by being your business advisor as well. When you're looking to expand and grow your business, the people you bring on board are critical to accomplishing the same. In this two-part series, we will provide you with some tips on interviewing candidates, the do's and the don'ts. This video will focus on what not to do. The interview process is more than just a formality before onboarding your new hires. Interviewing can be a costly action if it is not executed properly. What I mean by that is twofold. First, if you ask inappropriate questions, even unconsciously, you open yourself up to legal risks and the possibility of being sued. And secondly, if you ask the wrong type of questions, you won't be in a good position to hire the best talent. Employers can be liable for the discriminatory conduct of their employees, even in the recruiting or interview process. As a result, it is critical your employees involved in the recruiting process are trained to spot and avoid potentially discriminatory practices. Federal employment anti-discrimination laws prohibit multiple different types of discrimination. A couple include race, color, and gender. As with anything in law, you might be wondering if there are any exceptions to the prohibition against employment discrimination. Title VII of the Civil Acts Right of 1964 does allow for certain limited exceptions to the prohibition against discrimination, which include a bona fide occupational qualification exception, commonly referred to as a BFOQ, along with religious exceptions and exemptions. The specific requirements of the job will dictate if either of these options could apply. Avoiding discriminatory questions. Polite personal conversation may accompany an interview, but indirect or inadvertent questions about any of the protected class characteristics, some of which I just mentioned, can provide grounds for discriminatory claims. Employees conducting interviews should not inquire into personal details that might reveal protected class information. Questions should focus on gathering information necessary to determine the applicant's suitability for the position that they are interviewing for. So let's consider a hypothetical. A role will require a prospective applicant to manage a team of all men. An employer rejects an applicant because they are worried the female candidate cannot handle managing a team of all men. Moreover, the applicant shared that she was planning to start a family in the near future. What are some potential legal issues here, if any? Well, for one, gender. Gender is a federal protected class. Rejecting an applicant because she is female and has shared that she wants to start a family soon can be construed also as pregnancy discrimination. She may already be pregnant. If there are reasons outside of the applicant's gender for why she could not manage a team, it is acceptable to reject based on the lack of skill set or experience. However, if this concern stems purely from her gender, this is completely unacceptable. Here's a tip. Your procedure should ensure you are documenting the specific reasons when you are rejecting any applicant. That way you have a paper trail if you ever need it. And this will demonstrate why the applicant was not selected. For example, potentially a lack of history of leadership. That's the end of this video. In part 2, we will focus on what you should be asking candidates during the interview process. If you have any questions, please visit our website at mnklawyers.com or email us at info@mnklawyers.com. Don't forget to like, comment, and subscribe. Thank you.